Cool.
Thanks, James. Kick off. First question is essentially, where should people think about starting? So what's the kind of starting point if you're looking at transfer pricing for the first time, or I guess you're reviewing a transfer pricing position for the first time? What would your view be on where to start?
Okay, cool. All right. So I think the first thing to really think about is, when you're considering transfer pricing, you want to think about whether it's going to be relevant. Okay. So there's going to be a number of ways that we're going to potentially look at this. Especially for scaling companies, we need to think both in terms of, actually, do we have a requirement to do transfer pricing? And if we don't have a requirement, should we do that anyway? So let's just kind of boil it down into when we have a requirement. So from a UK perspective, and we need to look at this both from a UK and from a more global basis as well. So in the UK, we know that there are SME exemptions. But as I said before, you might choose to basically override that and consider to put transfer pricing in any instance if you have overseas entities. So we know that there are kind of exemptions, there are relevant thresholds. Each country, by the way, has different thresholds. So you therefore need to consider, if you've got operations in the UK, but also in other jurisdictions, what that might mean. And we'll touch on a few of those today. But for UK purposes, we're generally looking at somewhere greater than 250 employees, more than 50 million euro balance sheet turnover, and 43 million balance sheet. If you meet two of those criteria, you're likely to fall within the transfer pricing requirements, and therefore there will be a requirement to do that from a UK perspective. If you don't hit those limits and you're deemed to be an SME, there are three different reasons why you may choose to implement transfer pricing, or you might be required to implement transfer pricing, I should say. So if you have an SME doing business with connected parties, i.e. group companies, located in countries that don't have a double taxation agreement with the UK, so for example, Brazil is an example of one of those, or a country that does not have a suitable double taxation agreement. And by suitable, what we mean here is it's not considered to be an individual country by HMRC. So examples for that might be Jersey, Guernsey, and Hong Kong. Then they can remain subject to transfer pricing rules, even if you're deemed to be an SME. So you therefore just think about, if you have any activity within the wider group that sits within those countries, you might need to actually think about implementation of transfer pricing. The second one is, if you're a medium-sized business, HMRC can issue you with a notice in order to file your transfer pricing. Again, I think that's quite rare. We don't see that, often coming up. And the third one, which is kind of prevalent for tech companies, is an SME is party to. If an SME is party to a transaction which involves Patent Box, HMRC may issue a notice to require companies to compute profits in accordance with transfer pricing. So they're the three kind of key areas that we see if you're an SME, where there may actually be a requirement in order to do that. Now, the other thing that I mentioned earlier also is, not all countries have exemptions, right? So we know, for instance, that the US don't have a de minimis limit in terms of transfer pricing. And therefore, there is quite often the question, when we've got expansion into the US market, the question being, what transfer pricing should we implement, and do we have a requirement to? Now, technically speaking, there is likely to be a requirement in order to implement transfer pricing. And we'll touch on what that fundamentally means for kind of like a scaling technology company. But the IRS would have a requirement that you do that. We've seen also with countries like Spain and Australia, they also have de minimis limits or reduced limits in terms of actually implementation of transfer pricing. To bring that into context with a transaction we saw recently, we were working on a transaction where we were working with a larger tech company to buy another UK tech company that had a Spanish subsidiary. It had a Spanish dev center. and they'd never considered any transfer pricing between the UK and the Spanish entity. Now, it was really interesting actually because we picked up on it as part of the wider transaction review, and we had to go and seek local advice in Spain in relation to it. Now, because it was a dev center, and I know we're going to come on and talk about different entities and how you might classify those and the transfer pricing metrics that we'll look at here, it should have just applied a very simple cost plus methodology. Okay. Now, they'd never considered that, and it had just been a break even or loss making entity. Now, the Spanish advisors on the transaction ended up having a field day with this because they said the lack of any transfer pricing gave rise to really penile penalties and interest, actually more than the tax that was at stake, which was a really interesting concept when we were looking at this. So it became quite a concerning area because the company had this dev center in Spain for something like 5 or 6 years, and the penalties actually got quite disproportionate in terms of the transaction and how, what needed to be taken in terms of putting sufficient indemnities in place in order to satisfy the potential acquirer that there weren't going to be these penalties that were given rise, or actually they could substantiate the penalties and make sure that wasn't the case. Yeah. So we have seen that in a number of instances in the past. Again, the US, as I said before, doesn't have a de minimis limit. Australia has a relatively reduced limit as well. So again, don't just assume that because the UK has a de minimis limit, other countries also follow suit in relation to that.
Just in terms of, I guess, stepping back from all that, it would be quite easy to conclude in certain instances that I'm an SME. Yeah. There's not a requirement on the other side in terms of the other country, say, so I'm just not going to apply any transfer pricing. I guess if you're in those situations, are there benefits in still considering applying transfer pricing? And when we're talking about, I think just a caveat, when we're talking about transfer pricing in the context of scale-ups, which is really what this session's designed for, we're not talking about super heavyweight exercises. We're talking about quite light touch exercises. So yeah, is there I guess, should you still consider it even if you're really not meeting the rules at either end of the transaction?
Okay, cool. Kind of ask 2 questions there, which is, there are different levels. Let me answer the first one, which is there are different levels. When we talk about transfer pricing, right, let's not automatically go to the fact that you need to kind of write kind of Bibles or master and local files for everything and anything, okay? The view that we quite often take here is that we want to prepare something that is sensible, scalable, and proportionate to the size of the business that's required. Now, that's obviously going to take into effect what we refer to as a kind of functional analysis, which is basically looking at the risks and rewards of each entity within a wider group. And then kind of attributing what each business is doing and then working out actually what the transfer pricing methodology behind that will look like. So if someone says to you, you need to do transfer pricing, I think that what everyone almost immediately assumes is there's going to be shed loads of work here. It needs to be refreshed on an annualized basis. It's creating massive master files. And actually, that doesn't need to be the case at all. It can just be something that's really sensible, a couple of pages, some inter-firm agreements that have been well drafted, and just consider the interactions between each of those entities. Okay. So, and again, I think if we're talking predominantly about tech companies as well, we're going to talk about it. We're either going to have dev centers or we're going to have kind of sales offices, and we just need to work out which of those we have. And create something that means that you can then replicate the same transfer pricing in multi-jurisdiction is going to be really important as well. So back to your point, if you are an SME, should you have transfer pricing, or should you think about the implementation of transfer pricing? Now, there's a number of ways to answer this. What we quite often see is when a business starts to set up overseas operation for the first time, and they move from a kind of centralized contracting model where they had a single entity to multiple entities. Now, what we're going to assume here is that those local entities are going to be contracting entities. So I'm going to give an example here, right? So we are a UK-centered business, right? And we want to then go and set up operations in the US. Okay, if anyone's actually heard me speak before about internationalization, quite often that decision to grow into the US is led not from a tax perspective, but it's generally led either from a customer perspective where they're turning around and asking to engage directly through a US entity under US law. So that's maybe the requirement why you're thinking about setting up that local entity in the US. Or alternatively, you're doing it from a protective measure, right? So let's go back to our example. We've got a UK centered business. That business in the UK is our, let's just call it our holdco, our finance co, our IP co, our opco. You know, it's got everything in there, right? But most importantly, it's our IP co. Now, if we want to then start selling into the US market, we may choose to have a separate entity in order to do that, to have a separate entity, a separate there living corporation, to have some level of protection, especially if it's a sales office that allows for a delineation between the US and the UK entities. So that if there was ever a lawsuit that was raised in the US, it then necessarily wasn't being passed through the US into the UK entity, but it's being caught in that US entity. Okay, so there is a level of protection there that is afforded by having a sales office in the US. Okay, now if that's the case, then what you may start to do is you will start to then push contracts into that US entity. Okay. Now, if you're going to push contracts into that US entity, you may then have revenues increasing, but actually you might then not have the kind of lag in terms of, or you might have a lag in terms of the cost base. So what we quite often see with scaling tech companies is a UK business, right? Going back to what we had before, Topco, Opco, Finance Co, IP Co. It's developing its proprietary technology in the UK. It's going to be heavily loss making, okay? And then what we may then start to think about is we're then going to have overseas sales operations, and that sales operation is going to have revenues being pushed through it, but not substantial cost base. And that's only going to lead to disproportionate level of profitability in our example before of the US entity. Large revenues, small cost base, therefore disproportionate profitability. Now, quite often, what we then do is we're then advising our client base, well, actually, how do we fix that? What is the mechanism by which we fix that? The mechanism of fixing that is basically transfer pricing. And again, you therefore don't need to think necessarily, you don't need to wait until you have breached your SME limits in order to do that. You then think about early implementation of transfer pricing in order to fundamentally reduce or increase the cost base in the US entity, right? And we'll touch on the different models that you may choose to use there. And then you'll then recognize income in the UK entity. But again, that'll be franked against the losses that you're creating through the development of technology, the marketing, the senior hires, and all the rest of it. So again, I think what we quite often see is yes, you might not have a requirement to implement transfer pricing, but actually you may choose to implement it because it starts to mean that you don't need to pay taxes in jurisdictions at an earlier point than necessary. So that's the main reason why I think quite a lot of scaling businesses will think about that implementation. And going back to the first point I raised again is you just need to put a mechanism in there that gets you to a kind of a margin that would be acceptable. And we'll touch on how and what that margin might look like.
Yeah.
And in order to do that, you need that sensible, proportionate and scalable model that fundamentally just says, actually, this is what we're doing in the US, this is what we're doing in the UK, and as a result, this is why we're implementing it. Now, the other point I raised was you're then doing that both from an HMRC perspective, from an IRS perspective, because fundamentally it's making sense also from a commercial perspective. But if I was looking at this business from a transaction perspective, this would make perfect sense to me, right? That you would implement transfer pricing and you'd put something on file that you could then you could go back to and say, actually, the reason why they've done this and reason you've got a kind of explanation from a diligence perspective and demonstrating to potential investors or acquirers that the business is thinking strategically about the direction of the travel of the business.
Okay, so I'm just going to pick up one question at this point before we move into another section. Lucy, and it might be an it depends answer, but let's see if we can cover. Lucy's asked if you're an SME in the UK, size-wise, but you are part of a large organisation, as in US parent, for example, who's large.
Yeah.
And the group as a total triggers those thresholds. Are you technically covered, or can you still take the exemption?
No, it's looked at on a group basis.
Group basis,
so, yeah. So you've got to look at group companies within the wider group and aggregate up. So if you are, so let's take your example, if you're a subsidiary of a US entity and there are other entities in the group, Lucy, you have to look across the piece at all the other entities, and then determine, actually, are you an SME or are you large as a whole? Does that answer your question?
Yeah, I think it does.
Sweet.
John, Sophie, I've seen your questions. We'll hopefully cover those as we get in. I'll weave those in as well. So James, just coming to the next section, I guess just from your perspective, what do you see as some of the red flags that you would want people to take away when thinking about setting up transfer pricing for the first time? Maybe things that people have got wrong that you've seen, you've had to unpick or change, and that can get costly at a later stage.
Okay, there's quite a few areas where you just have to be a little bit careful. So I think the first point that I always raise is, and this isn't necessarily a transfer pricing, but an international tax area that needs consideration, is that when you're looking at transfer pricing and you're thinking about implementing transfer pricing across the group, take a step back for a minute, and think about some of the wider international tax considerations that kind of should really be thought about before you think about transfer pricing. So the one instance here that I'm going to mention is make sure that there has been due care and consideration about tax residency. And that's to do with where central management and control of entities resides. Okay, so there is often very little point even doing the transfer pricing if you've got your tax residency status completely wrong, right? So let's take our example again of the UK and the US subsidiary. Okay, now what we might have is a situation there, if you have a UK parent and a US subsidiary, and actually that you only have one strategic board meeting for that group per se, right? And that board meeting is undertaken in the UK. Fundamentally, that US entity has been centrally managed and controlled out of the UK via the board meeting. So that's one thing that you need to kind of stop and think about, because effectively, who has primary taxing rights on that? Now, if we look at the double taxation treaty between the UK and the US, there is no tiebreaker clause in relation to that. You generally have to go to mutually agreed procedures, it's called MAP, and work out who has primary taxing rights. Now, that takes a huge amount of time. And in the instance that we've just given there, it's likely that if the only board meetings are undertaken in the UK, that a US entity, although incorporated in the US, might actually be centrally managed and controlled in the US and therefore primarily taxed in the UK. So I think that's a massive area that we see go wrong. We've seen that happen and come up on transactions on multiple occasions. It's not the nicest one. It slows down transactions. If you have to go through a MAP process, that will take months, if not years, in order to resolve. You end up with double tax in certain instances when they credit offset. So again, I'm stressing this point, step back from the situation, look at the tax residency status in the first instance. And that would be my first point. Okay, so we've looked at tax residency. Then where else? What else do we need to think about? Let's take the example where we are transitioning from a single entity into multiple entities. Now, we often see this, and there's always an inflection point where we've got a UK standalone entity, UK co, holdco, topco, opco, IPco, right? And it then transitions into having, say, multiple entities. Okay, so let's go back to our US subsidiary example. So we end up setting up a subsidiary because we've got a client that we want to engage through that US entity. Now, the position that we've got is historically we were contracting through our UK business with US customers. Okay, and then the future position is we're now going to contract with US customers through our US entity. Okay. So there's a clear difference there. So the old versus the new approach. Now, one of the things we've got to be very careful about is if we move any of the existing contracts, US contracts, from our UK entity down into the US subsidiary, we can trigger what's referred to as an exit or migration charge at that point. Okay, so, and that includes even on the renewal of that contract. So just to be completely clear, the reason for that is the exit or migration charges will arise by virtue of the fact that HMRC will say, actually, there is an asset leaving the UK tax net, right? That asset is a contract, it's a future, it's a right to future revenues, and HMRC therefore see that as taxable income in their hands. Now, so if that is the instance, there is IP or an intangible fixed asset leaving the UK tax net. So what we can see quite often is that if that contract does transfer down without any due consideration, HMRC will then there'll be an exit migration charge. So be very careful when you're thinking about moving, novating, renewing contracts. Now you can get around it. Okay, there is a way through transfer pricing in order to move a contract down into that US entity by basically splitting the legal and beneficial ownership of the contract. But again, we can touch on that point. That's kind of quite a complicated point, but we can come back to it at a later stage. But you're basically being able to move and shift that.
Probably just wanted to add, it's probably worth stating that in a future funding round, you're likely going to get a question from a international tax person in a large firm asking you to state categorically, have you ever moved any contracts from one country to another? And you have to answer that. And if you have to answer it and say yes, and it hasn't been dealt with, then they're going to start to try to impute certain potential tax risks, which you don't want to have. So doing it at this point is or dealing with it at this point through the transfer pricing mechanism will be a good way to cover that off.
Yeah, I think the other point also is as I said before, like transfer pricing doesn't need to be too arduous. It can be light touch. So just work with someone that understands proportionality. Like I've seen so many instances where people have gone to town unnecessarily for businesses. Like most Series A, Series B businesses you don't need like, the horse and cart for transfer pricing. You just need something sensible and proportionate. There are different views taken as well, and I'm not going to go down this tangent about. We'll come on to this when we're working out to what extent should like a sales office have a profit margin, or should it be break even, or should it be loss making? Now, there's quite a lot of debate in relation to this, but I think we've got quite a firm view in terms of how that should be adopted. I think they're the kind of key things. So contract transfers, tax residency, making sure that you're aware of creating permanent establishment as well, because that has a knock-on impact in terms of transfer pricing as well. They're the kind of key areas that I would look at. But I'm conscious of time. We already got half an hour left.
Yeah, let's keep going. So let's get a little bit more into the definitions of what transfer pricing actually is, and into some of the models and benchmarks that you'd expect to be using to calculate some of these positions. And we'll also use some examples of certain structures, etc. So do you want to start with that?
So let's just touch on like transfer pricing, really super high level. So I'm only going to spend like a minute on this. So businesses may carry out several economic functions in different entities within a group. So they might have strategic management, so for control over all functions and exec management levels. They might have sales and distribution entities. They might have R&D and IP development entities. So transfer pricing basically looks at the functions and the locations in different entities, depending on the functions they perform. It's creating different functional profiles that impacts the remuneration that each entity should fundamentally receive. And that's basically what we're doing. We're looking at and determining what a arm's length, a fair market value would be in terms of payment between group entities. And that's fundamentally what the basis of transfer pricing is looking to achieve in many ways.
Do you want to get into some of the models?
Because
I think that's ultimately everyone on this call will have, or potentially will have in the future, either the development centre situation offshore. They'll have sales offices offshore, or a mixture of all of the above, and how the models then need to reflect that.
Yep, got it. All right, so should we kick off with dev centers?
Yeah.
I think this is going to fundamentally fall for like tech companies. It's going to fall into two buckets, right? Dev centers and sales entities. So let's just deal with those. So dev centers, just in case there is anyone on the call that's not, not aware of this is an overseas entity that's developing R&D on behalf of the UK parent. Okay. Just a commercial point to stress before we get into like the transfer pricing. Just be really careful when you have development centers. I know quite a lot of people will use EORs in order to develop that as their kind of overseas kind of dev center. My biggest concern here actually again isn't a tax related one. It's just making sure that the IP is where you want it to be. One of the things that will make your transfer pricing, your international tax far easier is if you have simplicity. And quite often you want to avoid complexity. So when we have dev centers, just make sure it's really crystal clear. Your dev center, let's say we're creating a dev center in Romania, right? Your dev center in Romania, you are basically hiring a team of individuals. It's likely that you're going to set up a local entity in Romania. That will be a 100% owned subsidiary, which is going to make it super simple for today's purposes. The entity will hire the Romanian developers, and a couple of things that we want to think about. Right, so let's start with the non-tax ones. One, we want a kind of license agreement firmly in place between the Romanian entity and the UK entity. Why would we do that? It's because, again, we want to make sure that our IP is in the right place. So that means that any of the development that's undertaken in Romania, the IP is firmly, legally and economically owned by the UK entity, right? So that's the first thing that you absolutely definitively want to put in place. In terms of the, intragroup, the transfer pricing, generally what you're going to do with a development center is you'd expect if you didn't have the Romanian entity, how would you price that? What would you do? Now, generally speaking, what you're looking at here is that you're looking for an arm's length charge. What would you pay a third party to develop that technology on your behalf? So here, the model we're looking at is just a cost plus. Okay. Now, I would expect that cost plus to generally sit somewhere between the 5 to 10, 12% bracket, depending on the level of seniority of staff within that country. So again, it's very simplistic. I think in our example, the Romanian tax authorities, again, would expect to see that kind of 10% gross profit margin residing in that entity. And that's exactly what we'd expect to see. Just to be aware, there are going to be countries where that margin is going to be higher. There are just preconceptions by the local tax authorities that it's going to be higher. India is always a good example of that. That's probably sitting somewhere between the 15 to 20% mark in terms of what their expectations of a cost plus dev center are likely to be.
James, there's a question from Idris on EU entities and having multiple EU entities. Can you effectively just blanket apply the same rate across?
Sorry. I don't know if it's my side or your side.
Yes, sorry, I think someone dropped. Would you expect to be able to apply the same rate across all EU entities, or would you need to look at each individual country in the EU to apply different rates?
I think what you need to do there is you need to look at the activity that was undertaken with each of those entities.
So yeah. If the entities were all similar entities, as in, they were all sales entities, for example, then you'd be applying similar rates.
Correct. Yeah, I wouldn't expect across Europe. I wouldn't expect there to be a disparate. We'll come on to this. It will depend on what the individual is doing within country, it will depend on if they are what's referred to as either a limited risk distribution model. If they're all limited risk distribution models, I would expect the rate to be very similar. There's going to be a secondary model we're going to talk about, which is referred to as a fully fledged distribution model. Again, depending on which of those they fall within, then that might have a different approach that might be required.
Okay, let's get into the models. Let's get into the models then, we'll talk a bit more about maybe the how the rates may vary. Yeah.
Okay, cool. So as I mentioned, there's mainly two models that we look at when we're looking at a sales office: limited risk and fully fledged distribution model. So essentially, let's just use our US example again. We've got a US entity that's selling directly to third-party customers, right? We need to assess the degree of interaction between the customer and those involved in the marketing and sales activity, right? So the sales entity might have the following features. It has the right to distribute underlying IP from another group company. It doesn't necessarily have strategic marketing activity and does not develop any marketing itself in the US of any intangibles, but beyond the local customer lists. HQ is responsible for the pricing strategy of the sales entity. So the US entity in this instance has limited ability to negotiate main discounts, and the main warrants and the risks remain with the main UK business or HQ IP owner, right? So that's normally the case that we see with quite a lot of sales offices that we have, right? So actually, it doesn't have a huge amount of autonomy. It's not particularly entrepreneurial in its own its own spirit, right?
Yeah.
It basically you hire some salespeople, you drop those salespeople down. They're reliant on the group's wider IP. They have boundaries and they have kind of parameters by which they can set the pricing, but actually they're not autonomous in terms of making that decision-making process, and they're reliant on central marketing and resources. Okay, so I think this is normally what we see is when you set up a local entity, a sales entity to start with, that's very much a model that we'd expect to see. This is commonly referred to as, I said it before, the limited risk distribution model. And it's basically, when we're looking at this model, you're looking to determine the profitability of the business based on a bundle of activities that are arising from the UK. So what you're looking at here is it's basically a bundle of kind of strategic management, services and support, IP and finance costs, and they bundle it into a single journal entry. Okay. And it's what that's looking to do is you're basically bringing it together to impute an operating profit level based on transfer pricing rules. A limited risk distribution model, basically, generally as a rule of thumb, we'd expect there to be an operating margin somewhere between the 2.5% to 5%. Okay. And what that's doing is it's basically demonstrating the kind of limited risk that the US entity is taking, and actually all of the benefits that would be attributable to that US entity. So there should be, if you pare back for a moment, think about the fact that this business has received the underlying IP, it's received the marketing. As such, it would make sense that this business should, if it was an arm's length, if you're paying a third party, make a small profit margin to represent fair trading. So you would expect there to be a small operating margin in relation to that. And quite often
on the flip side on that, if you had, for example, one of the founders had moved to the US and was fundamental in the go-to-market strategy of that US business, that would ultimately start to change that percentage that you'd be considering to use, presumably.
Well, so then we might flip, right, from a limited risk distribution model, so we don't have that much it's not that entrepreneurial, right, into the second model we're going to talk about, which is the kind of fully fledged distribution model. So that's where the entity may perform some commercial management and investment functions. It may provide kind of brand and customer contractual support underlying the strategic marketing activities, and therefore it becomes
an entity in its own right.
Yeah, so it has more brand awareness, more customer relationships, it has more commercial know-how, And it starts to almost represent and create its own intangible fixed assets in country. So let's just be really specific here. It becomes more entrepreneurial, right? And there's a shift in the value or the value to customer relationships at this point. Yeah. Now, what's interesting is when you move into that model away from the limited risk distribution model, the profitability is computed in a completely different methodology. So before we talked about that bundle of services from the UK, you don't really need to disaggregate each of that bundle. It's just a simple composition of management charges, finance, IP, license charge, right? All together to give you a operating margin. Now, when you start to move to that more entrepreneurial, fully fledged distribution model, you actually start to look at each service line provided by HQ, be that strategic management, tech support, back office, any of the debt, and you're looking at assets put to the US entity's disposal, and they're separately looked at and separately priced. Now, given the fact that entity becomes more entrepreneurial, it is fair to then say, actually, that entity doesn't necessarily need to generate a profit margin. It can create a loss because, as you said before, it is more entrepreneurial in spirit. And if we're looking to benchmark that against kind of other businesses, third-party businesses, you don't necessarily need to say it would or should be a profitable enterprise in that regard. So to your point, if you have a founder that is moving to the US and substantially moving the activity from a kind of less entrepreneurial, less risk-taking enterprise to a more, let's call it a fully fledged model, then actually you may then be able to fall within and start to generate a loss. And therefore that has a slightly different approach that may be adopted. Yes, absolutely.
Okay. I guess there's a question that came in from John around picking suitable rates. And there's this term bandied around of OECD guidelines, which everyone seems to refer to, but maybe not everyone's clear exactly what that necessarily results in. So yeah, how much depth would you expect there to be behind the selection of the rate? And what are ultimately the benchmarks and the reference points in which we should be using? And what's your view on the risk attached to the selection of those rates?
Okay, that's a good question. I'm going to answer that in two ways. I've answered everything in two ways today. You never get a straight answer out of a tax person. Right. We're answering that if we're an SME, and I'm going to answer that if you're a large enterprise, okay?
Yeah.
So as an SME, I think it goes back to that first point, right? And if you talk to me at any point about transfer pricing as an SME, sensible, proportionate, scalable. That's all I'm ever going to say. Finding a model that works and sticks. Now, there are OECD guidelines, there's benchmarking analysis that's fundamentally undertaken. I think as long as you're working with someone that's providing a sensible range and that you have basically appraised that range and come up with a sensible solution as to where you sit within that range, top, middle, or bottom, then actually that seems like a sensible approach for an SME. Yeah, that's my answer, right? And when it comes to due diligence, right, as long as you're in a position where you can then stand behind that number and provide support as to why you've chosen that over the period, like over the number of years, then I think that would be sensible, right?
Which may only be, as you said earlier, may only be a couple of pages of narrative support as to why this is a reasonable position to take.
100%. So yeah, and look, I think let's just be really honest here. If you're an SME and you've chosen something that seems to be proportionate, then that would be sensible. Now, if the numbers are starting to get material, you may want to take more comfort over those. And actually, therefore, or not only from a tax perspective, but I'm assuming, kicking it back to you for a second, from an auditing perspective, you would want to get some validity over actually those numbers. So at that point, you may choose to get some more benchmarking analysis undertaken, and actually have that fundamentally on file, so that as a result, if you ever need to show that to auditors, let alone the diligencers, let alone the tax authorities at a later stage, you would have a complete audit trail in terms of all of those areas. So I think, yeah, when the numbers start to get material, that's where I'd probably think about considering a benchmarking analysis and study to be taken. And just to be completely clear, to finish the loop here, if you're not an SME, I think it would be sensible to go and get benchmarking done, because you are going to need to do master and local files in any instance, and therefore it is a requirement. Cool. I think I answered John's question.
Yeah, I think you did. So just coming back to Sophie's question, which I think we've sort of touched on a bit here, which is basically UK SME has TP in place for the company scaling. How does it affect the TP as the company's scaling? So what we're saying here is that as the business is evolving in terms of the business model of what's going on in the different countries, that could then affect the TP, because ultimately each country could be undertaking different activities.
Right.
That's not necessarily just because of scale. That could just be happening even at the same scale. So but the scaling up obviously is bringing more risk into the fact that is happening and should be considered. But then also there's going to be certain limits in certain countries which you may, as you scale, end up becomes more of a risk, or it becomes more material generally to the way in which the business is reporting. So that scaling up is probably more about the activities of the business and the relative size of the business versus the benchmarks in country.
Yeah, I think from my perspective, if there is a concern here, I think actually there is a well-trodden path here, which is, I think a lot of when you set up sales operations, so let's part the dev center, because we can almost kind of go, right, we've got a UK business, we've got a dev center, cost plus seems to be appropriate, right? Super easy. Take that one off the table. And then as we grow and scale operations from a sales perspective, actually it's a pretty well-trodden path. Most of them will be limited risk distribution models based on the fact that if you're holding like centralized activity in the UK to start with, that's generally the model that you're going to have. And then as you then grow and scale and those local entities become more entrepreneurial in spirit, that's when they'll move away from those limited risks to fully fledged. And again, that will take a period of time to happen, and then it's becoming to become more entrepreneurial, really to then push into those entities. So let's go back to that for a minute and then go, well, actually, all we need then is something really sensible and proportionate that allows us to grow and scale and have a similar model and principle for each of those entities as we grow into new countries. Now, that's not only important that you work with someone that explains that to you, but you need it so you don't have a multitude of different models that you need to then implement. And also that from a kind of, there are a number of ways of looking at this. Do you then kind of have that as a kind of year-end journal that you're just posting through? But actually to have this as a kind of management account pack as well is super helpful. We know companies that do that as well, and therefore they can get to a place where they start actually recording those on a monthly basis. So again, yeah, finding something sensible, proportionate, scalable. Sorry, I sound like a broken record, but it really is. My view is it's as simple as that.
I'm just going to pick up a question from Paul, which is referencing if you have effectively a R&D offshore dev center, and the intention is that all the IP is flowing back to the UK.
Yep.
Is it sufficient to use cost plus model as proof that the UK parent co has ownership, or should you have a formal, bigger IP agreement in place? I think I know the answer to that, but I'm asking the question anyway, so you can answer it directly.
I would definitively have an IP license agreement in place, right? Definitively. To demonstrate where that is, and within that will demonstrate the pricing methodology by which you are then remunerating the dev center for. So sorry, was it Paul that asked that question?
Paul, yeah,
Paul, definitely. The reason being, you just want it crystal clear. Like, one of the questions that you don't want, so let's just take the example where we're going to have a sales office, we're selling the IP. We don't want there to ever be, the question ever asked is, where is the IP coming from? Where are you selling it from? And to have split IP created unnecessarily just creates so much tension, and you just avoid it at all costs. So yeah, I think hopefully that's answered the question there. I'm kind of a firm believer of keeping it really simple, unless there is a requirement to have complexity. Cool. All right.
Yeah.
Thanks, Paul.
Yeah.
I think that's answered the question.
Ben does have a question. I think it might send us down a bit of a rabbit hole.
Awesome.
So it might be one to pick up offline. I mean, it's a question connected to a US loss-making, a US company that's loss-making, that's being funded by the UK, basically.
Yeah.
And it's receiving, support payments from the UK. What kind of model would we expect to be in place there? Because obviously it's already receiving support from the UK, and it's only, I guess, heading one direction in terms of, its loss-making position. And there's a secondary part to his question, which is about if all the decisions being made in the UK, how does that impact the position in terms of US residency?
Okay.
That's why I said it's a bit of a rabbit hole, but
I don't have 10 minutes to do that.
Yeah.
But Steve, if I tell you what, do you want to just drop me an email, whoever sent that?
Yeah, we'll pick up. Ben, I think it might be one to pick up. We can do a quick one-to-one on that. I think it's because that'll probably be a 20-30 minute conversation around some of the factors there. So yeah.
And similarly, if anyone else on the call wants to just like hash out something for like 15-20 minutes, half an hour, just give me a shout. If you don't want to ask specific questions on the call today, just message me afterwards and we can have a separate one-on-one. Happy to do that.
Cool. Just as we start thinking about wrapping, what kind of documentation would you expect businesses at this stage to have in place? And I guess what's been your experience of seeing that passing diligence events in future fundraising situations?
Okay, cool. So let's just take the easy approach here. So if you're a large entity, you would expect there to be at least a master file and then local files for each of the relevant subsidiaries. That is where there is probably more in-depth material being created. This isn't the kind of 2-3 pager that necessarily needs to be done. So that is quite an involved project. But again, working with someone that can be proportionate to the size of the business, not kind of going to town on absolutely everything, is sensible. If you're an SME, as I said before, like you just need something that fundamentally has a functional analysis. Functional analysis looks at the risks and rewards of each of like the entities within the groups, starts to evaluate those in more detail, and then fundamentally pulls together a schedule that says, look, we know where the risks are, we know where the rewards are, well, this is the level of services. And if we're looking at a limited risk distribution model, for instance, it will fundamentally look at, the IP license elements of it and how that should be priced up or considered. It will look at finance elements within the group, and it will look at management charge areas within the group as well. And fundamentally have a consideration for each of those as well. That's the main thing that I'd look at, functional analysis. And then off the back of that, the lawyers will then be able to draft inter-firm agreements that fundamentally reflect the pricing mechanisms that exist, that you've considered based on the parameters of the relevant model and the pricing methodology. That's pretty much all I'd expect to see.
And how much does that get challenged in diligence in your experience?
Interestingly, so it will, for most businesses, it's kind of the questions actually, so the question is asked when they've done absolutely nothing, or alternatively, where they've just applied the wrong model. So like quite often people have just taken shortcuts and they're still using cost plus for sales entities, which let's just be honest, is completely wrong.
When the business has totally moved on, and yeah.
So depending on where the business is and what they've been doing. So look, I think over the last few years, if you've had a business that's gone and set up in the US, for instance, and it's using cost plus, but actually it's kind of moved away, it's not really emphasizing on the US. Yeah, it's a risk, but let's just be really honest about it. It's not a major red flag. I think the concerns are, transfer pricing is a concern where you've just used the wrong model completely, where you need to think about it in more detail. So yeah, I'd raise concerns there. I'd want it to be looked at. The concern is that you've applied the wrong model, that you haven't considered a pricing mechanism, that, you know, if this needs to be a margin discussion as opposed to a cost plus, again, you know, have you been working it out? Do you have you misrepresented and paid the incorrect amount of tax overseas? Question mark, how material that is to the wider transaction. Questions like that need to be asked. You know, bigger issues that make deals fall over is stuff like the contracts, transferring contracts, that kind of stuff. Wider international tax.
PE risk not considered at all.
Yeah, PE risk, that always comes up at the moment, left, right, and centre. But yeah, I think for me, it's more like, let's not kind of labour on, is it a risk, like transfer pricing? It's more just sensible, pragmatic implementation, right? If you don't have it, you're going to end up with disproportionate levels of profitability for sales entities. So think about it. And SME should just put it in place anyway. So I'm not saying I'm seeing loads of risk in relation to it. I just think it's simple commercial sense to actually implement it rather than anything else. But implement it correctly. And you know, I'd expect there to be some substance behind and some consideration behind. If I was looking at a transaction, I wouldn't expect there just to be a nothing. I've just done a year-end journal and done X, Y, Z. Like, I wouldn't expect to see that.
Just in terms of giving people an idea of the range of what fees and advice one might expect to take when you're in maybe in this position. Let's just say that you're coming at this pretty cold, i.e. there's a relatively new expansion or there's no transfer pricing really in place that needs to be thought through. What would your range of fees be that people should expect to be paying?
I think if you've got a dev center, it's not going to be particularly expensive. Like, I think just having a sensible, pragmatic plan in place, somewhere around the 5-6K would be sensible. When you're starting to look at sales offices, obviously that's where you need to start being a little bit more involved, putting together a little bit more substance behind the functional analysis. Somewhere sensible there would be somewhere between the 10 to 15K mark, to be honest. But again, don't do this. Like, again, you want to make sure that you are looking at wider international areas. Don't just go and do transfer pricing without looking at tax residency, PE, and other areas as well. Like, make sure you're talking to a provider that looks holistically. The issue is that most transfer pricing people, some of them have international tax experience and some of them don't. Find out, like, you want to work with someone that's a little bit more agile, that has a little bit of both. Preferably you want someone who's got a bit of transaction support as well. You can kind of benchmark it against, I did this again on this transaction, I saw this issue arise here. That's the kind of conversation you should be having, and that really kind of helps you kind of guide you in terms of working with the right providers.
Just final question. I've seen a few people grapple with this whereby they've expanded into the US and they've used a firm in the US or a law firm in the US to help them set up in the US. And then the law firm or whoever it is that's done it is trying to sell them transfer pricing advice from the US. Which is a bit of an odd one in that, you know, it's a US market issue, because for UK you could argue it's not an issue, but equally it's very one-dimensional. So what's your advice on that, and then we can wrap?
I don't love it. My preference is, if you're a UK centric business, right? So the IP, the finance, the management charges are all coming out from the UK into overseas jurisdictions. The problem you're going to have is if you work on that model, it goes back to the fact that you're then going to have, you've got a US model. Then if you're then going to go into, say, Spain, or you're going to sell anywhere else in the world, the question you're going to have to ask is, can I use that same model that the US have created for me elsewhere? And I think that's a bit of you're just going to end up replicating or having different models for different entities around the group. So look, the way I look at this is, it's more sensible to have a UK centered approach if you're a UK centered business, i.e. you're a UK IP, like UK IP co, opco, and then you're pushing out and developing and growing overseas. That's how I would look at it. You may want to then get UK advice to drive the emphasis of the transfer pricing, and then get that substantiated if needed overseas as well. So that's the way I'd approach it. Don't, because imagine a situation where you set up like 6 or 7 different entities. What are you going to do? You're going to get 6 or 7 different transfer pricing methodologies from each of those. Like, it's going to end up being more costly. You're going to end up with different people telling you different things. You can have different teams driving it. It's much easier to have a centralized team driving one single policy. Like this isn't even tax. This is just simple commercial considerations.
Yeah, agreed.
All right, cool.
Okay, we're up on time. Thanks everyone for staying on and for hearing us out. Hopefully, give you some food for thought. Anyone that wants one-to-one to go through their specific examples, we're happy to do that. So let us know, and look out for some more of these sessions in the new year. Appreciate it.